Assalamualaikum to Madam Yus. I and my friend want present about estate planning. He is my team. First, me, Nur Ikilima Sofia binti Rukumal Hakimi. Second, Dayana Atira Najwa binti Marzuki. Third, Dayana Adiba Najwa binti Marzuki. Next, Siti Noshabika binti Amran. And lastly, Sarifah binti Niwar.
My name is Nur Ikilima Sofia. My matric is DPA 20210F4. I will present about individual ownership property. First, outright ownership. The broadest ownership of the property by individual. Hold unlimited interest in the property and has all the right associated with the property. Next, property right and the right of transfer to another in any time the property, title, benefit or the debt. Second, left interest, the individual right to process as the dividend income from the property as the ability but limited to the property of the life. Third, term interest. Property ownership refer to a property where the prevailing tenant has the right to possess as dividend income from property during the tenant term. Lastly, future interest. Vested and contingent current right of the individual to the future right to the enjoy a property. If the right is contingent, deal will become vested on the happening of the kitchen event. Next, I will present about joint ownership property. First is technology is common. Property is owned by more than one individual. Locking ownership rights will not automatically be transferred. The property of the decrease in owner interest in the property when the each owner has the right to transfer is the interest in the property to the other at the debt or any other times. Second is joint tenancy. Owner jointly by one and more individual with right of the survivorship, not realization to the ownership between the owner because the debt of a joint owner automatic transfer is the interest in the property to the surviving joint tenant as the property are classified as no-profit asset. The joint tenant may transfer in interest in the property without the consent of the other joint tenant as the acts if taken will effectively alienation the survivorship right tenant.
Assalamualaikum warahmatullahi wabarakatuh. My name is Dayana Adiba Najwa binti Marzuki. I am from DIBA 7C. My matric number is DBA 2021-26261. I want to present about estate planning. Estate planning is the process of managing and administering the asset of an individual through the accumulation, conservation and distribution based of life and effective and efficient manner according to the wishes of the owner. Important issue related to estate planning and to ensure our loved one are able to receive our asset as soon as possible. An asset are passed on the person of our choice. Most people assume that their estate will automatically go to their loved ones when they die. In many cases, this is not true. Many problems will arise without proper estate planning. Objective of estate planning. The first one is asset transfer among beneficiaries. Every individual wish to transfer his accumulated will among his legal heirs or beneficiaries. They may be family members, friends or other people. Estate planning ensure that this wish of the individuals go fulfilled either during his lifetime or after his death. B. Lower tax payment. One of the most important objectives of the estate planning is the transfer of maximum wealth and payment of minimum taxes. C. Incapacitation. Estate planning sometimes is resorted to for incapacitation as well. This avoid court-controlled guardianship and the sole control remains within the family itself. Also, this reduce the cost of third-party engagement by a court. D. Proper succession plan. Estate planning includes writing a will as a part of financial planning. This helps in identifying the asset. Disposal comes with succession plan of an individual after his death. And the last one is E. Who should receive and when. Estate planning helps in preparing a well-designated will to distribute the wealth of the deceased individual among his beneficiaries. Sometimes a will clearly stipulates that a particular family's members becomes the owner of any personal effect till his minor child becomes adult, or a minor will become the owner of a particular asset when he reaches a particular age.
Assalamualaikum warahmatullahi wabarakatuh. My name is Dayana Atira Najwa binti Mazuki. I'm from Diba 7. My matric number is DBA 2021-26260. I want to explain about wills. In Malaysia, Amanah Raya Berhad administers deceased person's estate. The estate of the deceased are administered according to the categories of the estate. The categories are either intestate estate or intestate estate. When a person dies and leave a will, his or her estate will be administered as testate estate. With the will, the estate will be administered according to his or her wishes. But if he or he does not leave a will, then he or she estate will be administered as an intestate estate. This type of estate will be administered through summary administration, small estate, and high court. So for the first one is summary administration. Only ARB is empowered to administer an estate summary under the Public Trust Corporation Act 1995. Estates are summarily administered without having to apply for letters of administration from the High Court. For example, whether there is a will or not, the movable property is in Malaysia, and no person is entitled to apply for a grant of probate. Next, small estate. If the estate consists of movable and immovable properties not exceeding the value of RM600,000, ARB will administer the estate by making an application to the land officer for a distribution order or for the appointment as administrator of the estate. And the last one is High Court. If the estate exceeds RM600,000, ARB will be administered it by applying to the High Court for the letters of administration to administer and distribute the estate. Will. A will is a written, legally enforceable document expressing how a person's property should be distributed on his or her death. It will also include who will administer the will. However, wills are of the last priority for most Malaysians. A Muslim can only distribute 1/3 of their estate through a will, and another 2/3 will be distributed through faraid. But a non-Muslim can distribute all their estate through will. A Muslim will is an iqrar of a person made during his lifetime with the respect to his property or benefit thereof to be carried out for the purposes of charity or for any other purpose permissible by the Islamic law after his or her death. The concept of a will involves three parties, namely, the first one is testator. The person who makes the will, he or she must be 18 years and of sound mind. Next, executor. The person who administers and distributes the estate, the executor needs to abstain grant of probate in order to executor to have full power and responsibility to undertake administration of the estate. And third is beneficiaries, the individuals who will receive the estate according to the will. There is a requirement of a valid will. The first one is age of majority, must be 18 years old or older to legally to execute the will. Next, sound mind, must understand the act of the will and know the value of the property and who are they willing to. The last one is state laws. Typical requirements include the will being in writing or signed in the presence of witnesses. Next, there is duties of executor. So for the first one is identify the asset and beneficiaries of the estate. Next, to collect and realize deceased's asset. And last is to distribute legacies. Next, why people do not write a will. For the first one is people are not aware of the importance of having a will that would protect the future of their family. Next, they are think that writing a will is complicated and time-consuming job. The last one is some people think a will can be made by the old people. In fact, a will has nothing to do with age. Every individual over the age of 18 years should have a will, whether they are rich or poor, single or married. Next, benefit of writing a will. The first one is to avoid family disputes. Intention can be done orally, but sometimes the distribution of estate could lead to complication, especially when the husband has more than one wife. Next, to ensure the distribution of assets upon the miss will be done according your wishes. And last one is a medium for you to appoint the executor of your choice. An executor can be an individual or a corporation which is entrusted with the task of carrying out the administration of your estate in an impartial manner. Next, a will can be revoked. The first one is marriage. A marriage or remarriage, divorce or separation does not revoke a will. Second point is destruction. When the testator destroyed the will physically with the intention of revoking it. Accident or malicious destruction by a third party does not constitute revocation. And the last is conversion to Islam. When a non-Muslim person convert to Islam, because the distribution will automatically follow the faraid distribution.
Assalamualaikum, my name is Siti Nur Syafika binti Amran, TBA 20212441. I want to explain about distribution based on right of Muslim legal heirs. In Faraid law, there are three main categories of heirs: Quranis heirs, residuary heirs, and distant kidneys or relatives. In addition, there is public usury. Only the Quranic and residuary heirs are considered legit heirs by Faraid law and equated to Islamic. The main category is male who are residuary heirs in their overright due to the relationship with the deceased. Next, family who are residuary heirs to another as Quranic heirs are entitled to a 5 share of entitlement based on the Quran and Sunnah. The distribution to Quranic heirs take precedence over residuary heirs. Example is wife, husband, father, mother, and daughter. Next, residuary heirs. The share of residuary heirs are not fixed. They are determined after the share of the Quranic heirs have been determined. The father and the paternal grandfather are Quranic heirs but might be residuary heirs if the decrease has. Next, I want to explain about estate planning method during a Muslim lifetime. First, inter-reverse gift. A gift inter-reverse, a gift between the living in Latin, is the legal term that refers to a transfer or gift made during the grantor life. Inter-reverse gifts, which is include property related to an estate, are not subject to probate tax since they are not part of the donor estate heir. Next, Islamic trust. A trust Islamic law is known as waqf literally. Waqf means to stop, contain or to present, and is a voluntary, permanent, irrevocable dedication of one will to Allah. According to some Islamic scholars of a waqf to be valid, it should be settled for a pious purpose. Next, joint acquired property by married Muslim couple. According to Section 2 Islamic Family Law, State of Selangor, Enactment 2003, matrimonial property is defined as property that is acquired.
This is issue related to Farad. A Muslim is only allowed to give away not more than 1/3 of his estate in a will. If more than 1/3 of the estate must have consent from all the deceased heirs. If without consent, the heirs can only entitled for 1/3. However, writing a will to the heirs or beneficiaries even 1/3 and with consent of the heirs or beneficiaries is not. First one about hibah or gift. A Muslim can hibah his estate to anybody with the living duration, whether partial or all of the estate. For example, by transferring the name in the house title, car, or land. Asset which can be placed under the hibah trust consists of movable asset and immovable asset with value. This asset must exist during the contract or akad. Movable asset include cash, bank saving, and share. Immovable asset refer to assets such as building, house, and land. In the Islamic law, hibah is valid once there is ijab and qabul about the gift and that she or he wants to give away without consideration. It is haram to ask for the hibah, even among siblings. Husband and wife accept a hibah from father to the son. The beneficiary must be matured or baligh and of a sound mind. For individuals with disability or patients with mental condition, the giving of the hibah must be done through a trusted guardian. Second, nominee in insurance, EPF, tabung haji. In the Islamic law, nomination of the above are considered not valid or does not fall the nominee upon the death of the deceased. It is still contrary to the faraid. This is stated clearly by the Jawatan Kuasa Fatwa Kebangsaan 1973 in the Mesyuarat Majlis Raja-Raja on 20 September 1973. The nominees of EPF, post office having insurance, are the people who carry out the mandate or executor. They can receive the deceased money from those sources to be distributed to the people who are entitled according to faraid. That's all.